Welcome to BCTV. My name is Tom PERRONE, and I'm very honored to be your host and moderator today in today's program. The subject we're going to talk about today is the essentials of estate planning for retirees. So, hello everyone.
Hi.
I'm going to introduce all of you in one moment, but our special guest today is Michael D. Saffer, attorney for the Pellegrino Law Firm. Michael, thank you for coming.
Thank you.
Now, I'm very honored to have Michael here because he's a very good friend. And Michael, if I had to read your bio, we would be here a half hour. So since I know you so well, I'm going to cut through the chase. But Michael was admitted to the bar in 1965. He attended and graduated from the Wharton School of Finance, University of Penn, New England School of Law. He also has a Master's of Taxation from the New York University. He's been with the Pellegrino Law Firm since 1973, Michael.
Right.
Michael, if you looked at the reference of Martindale and Hubble, which is a resource that rates attorneys in ethics and expertise, Michael consistently through his career, which is a good long time, Mike, huh? Has always been on the top, and that's a high degree of caliber person we're working with. But let me give you something on the personal side. Michael and I have worked together for many, many years, and what Michael, as educated as Michael is, what Michael can do well that very few people, especially in the law field, he can take the complexities of these laws so that our clients understand them in a simplified way. Because of that, they implement what Michael suggests. So Michael, you communicate well, and we're going to use that today. I would also like to introduce our panel today, and I'd like to start to the left and introduce my friend, Polly Fitz. Polly, can you tell us a little bit about you?
Al and I, the guy to my right is my husband, came to Branford in 1973. But for most of my time in Branford, I've been away from Branford because my work was at the University of Connecticut and I traveled nationally a lot. So retirement was an education and grounding in the community of Branford, and I'm happy to be here.
Al?
And I'm her husband, Alan, or Al. We're in our 50th year of marriage. We are both retired. I used to travel all over half the world consulting, and it's good to be here in Branford without the travel for a while. So we're both kind of lived here a long time, but we've just been really in the community for the last 10 years or so. And we've been thinking about all kinds of questions about retirement as time creeps up on us. So I'm pleased to be here too.
Thank you, Al. Pat?
Well, I can't lay any claims. I've only been in Branford 3 years. I moved up here from with my husband from Maryland, the Eastern Shore. We had a full life in the diplomatic service and were abroad a good part of our career. And then I worked for 10 years in Washington, D.C. as a public relations executive. But our children decided to live in Connecticut, and so we are adjusting to life here. And originally I'm from Seattle and my husband from San Francisco, so we really had to learn to meet New Englanders who've been very welcoming.
Wonderful. Mary?
I'm Mary Weber, and I've lived in Branford since 2006. My husband and I moved here from darkest Westport. 2 years after we moved here, my husband died, so I've been a widow for 5.5 years. In a previous incarnation, I was an economist and a part-time volunteer politician.
Thank you. So we have a pretty good panel to ask these questions. So I would like to start it off by bringing up Pat. You originally, when you moved down here, you mentioned you had to start to learn the Connecticut laws. You had a question concerning wills and distributions that you wanted to ask Michael.
Yes, a couple of years after we moved here, my husband faced some surgery Yale New Haven Hospital. And we had our will, our durable powers of attorney, our healthcare representatives all done in Maryland. And to our amazement, they didn't want to do the surgery until we changed and got a Connecticut healthcare plan. And for that reason, about a year and a half ago, we found a local Connecticut attorney, and we redid all of our legal paperwork. And then my husband died unexpectedly last year, a few months ago, and I was so glad that we had things in order in the state of Connecticut. And I think it's very important for all seniors, but perhaps particularly women who tend to be the ones left to deal with these sort of things. So I think it's very important. I'd like to hear Mike go over some of those things.
I think it's a dual problem for people coming into Connecticut and people who want to retire and live in another state. That although the U.S. Constitution protects the validity of what we signed where we used to live, when we go to a new place, it looks like Japanese to the locals, and they want to see something that is familiar to them. So that one of the first things I say to people to do is immediately, as you had to do, have powers of attorney, appointments of healthcare representative, which is our Connecticut proxy with HIPAA powers, having a living will, and having something that you don't see very often, an appointment of conservator contingent upon incapacity. Because these documents are only as good as you have people named on them and there are backup people. So if you ran out of a backup person, that document expires because there's no more people able to serve your wishes and to protect you. Another thing that's very important is each state wants to tax us. So if I moved from Delaware to here and I didn't register as a Connecticut voter, Delaware would say, gee, you're filing your income tax return with your Delaware address still because your accountant forgot to change it. You're still registered here. So under the U.S. Constitution, each state is its own authority, and the U.S. Supreme Court says if they want to tax you estate tax-wise or income tax-wise, both together, you could pay a double tax. So become either a fish or a fowl. If you're coming to a new state, walk, look, and talk like a resident there, and remove yourself from the voting list where you were before, and register cars, and be a Connecticut person or be a Florida person. But those are very, very important things to try to do immediately.
You have to be a Yankee fan too.
We registered to vote immediately. We always voted absentee from overseas because that was something very important to participate in the government. So we were good to go on, we registered in North Branford. And
Michael, you bring up a good point, and we've had this situation with our clients many times, where you have all of these documents that need to be completed, but you need participants. And some families come into the state where their relatives are back in Oregon, and you're looking for an executor, executrix, an attorney of fact. How do you handle this when I come to you to have these documents done and I have one brother and no other relatives? How are you handling this?
That's a ongoing problem that many people have. They may have a brother, but they may not be close to that brother. Or they may name the brother as a backup person to serve on, whether it be an executorship or on a healthcare representative. But a lot of people don't realize that you don't have to be restricted to your family. You may be very, very close with people who live down the street, and you'd rather have them in control than maybe your sister Sally that lives in Westport. The other thing is, years ago, I had someone ask me about a guardianship. We have nobody we have available to name our kids as who our kids are going to have for protection as guardians. And people just tend to not look at the fact that there are people who are their friends who might do a better job even than a brother or sister or uncle or aunt or whatever.
So in many cases, what we've suggested to people basically, if you don't feel comfortable because you don't have the players, you're still better off naming someone than not having these documents, and make the changes later on.
Right.
Now, Polly brought up a good point, and she was talking a little bit about, you know, what's the real purpose of a will? Was that was one of your questions, Polly?
Well, my questions were mostly around probate and healthcare directives. So, but I'm glad to listen to other people's questions about wills.
Well, Polly brings up a good point, Michael, because I see it all the time. People are confused with probate.
Yeah.
They think everything's probatable. Can you explain to us how probate works? What is probate?
In less than 2 hours, I will try. Probate is the procedure of carrying out the process of moving assets out of a deceased person's name and into the name of the parties who are designated for those assets. Now, there's a misconception about probate, and that is that everybody, not everybody, but most people think that if I have a will leaving everything to Polly, and I have life insurance, annuities, IRAs, that the will, it says everything that goes to Polly is going to cover everything. Life insurance, death benefits, retirement plan benefits, and it doesn't. More and more people have assets that aren't will assets, are not disposed of by way of will. Life insurance that names a primary or a contingent beneficiary. Life insurance that might be payable to trusts to protect somebody or to avoid probate ultimately. IRAs. The IRA company or administrator is not going to pay Polly that IRA or make Polly the owner of my IRA if I have Al as the beneficiary. Even though the IRA may be worth $500,000 and my own assets are worth $100,000, Polly only gets the $100,000 that's in my name alone. So a will and probate's the other side of the coin of a will, is moving one name assets that aren't joint, that have no name beneficiary on them, and that are stuck in your name or my name, and the vehicle that's the beneficiary designation is the will. Mm-hmm. So you got to watch the ball as far as the nature of the asset that someone has when they pass on, as to what is going to move that asset and how to properly designate all your assets so they end up being consistent with each other.
That's very helpful.
And Polly and I were having a conversation about healthcare directives and how that has changed over the years. Michael, can you give us an idea of exactly what healthcare directives are?
Well, there are 5 major documents that I would describe as lifetime protective documents. And I'm going to mention them very quickly to show where the healthcare document comes in. You have a power of attorney, you have a living will, because without a living will, they have to continue you forever, even though your brain may be no better than this table. Because that's the law. And even if it wipes out your assets or both spouses' assets, that's the way it goes. There is a new document in Connecticut called an appointment of healthcare representative. And for the first time, Connecticut has a true healthcare proxy. So if I can't speak, someone who I've already designated as my healthcare representative is my medical spokesman. They can sit in the room with the doctor and myself. If I have a sore throat and I can't speak, they can be my representative. There is a HIPAA authorization in that one-page or two-page appointment of healthcare representative that authorizes whoever is my healthcare representative, despite HIPAA, can have all access to every single item that relates to my medical care and medical information so that they can make educated decisions on my behalf. So the other document I mentioned earlier, the appointment of conservator if someone loses their capacity, is important in order to, just like the healthcare representative, have people who you want and in what batting order to be there to act for you and to protect your wishes and protect your person.
Mary brought up a good point earlier in our conversation, and I believe it was Mary said, if you move to the state, immediately what should you do to get on par with what's going on in the state of Connecticut versus Oregon? What are those things that one should do? Is that what that was your question, Mary?
That was half of it.
Okay,
But
elaborate on
it's
that.
the first half.
Okay.
Do you want to elaborate on it so we
Did
get it
I
right?
ask your question
Yes,
for you the
did
right
indeed.
way?
You did indeed. The other half is that when you become another move, when you become a widow or widower, what should you do immediately? What should you do medium term, and what should you do
Good
long
question. Michael.
So when these are life changes, what do you need to do immediately?
I think that the first thing that one should look into is usually most people's wills, trusts, these lifetime protective documents are out of date. They're old. They could be 6, 7, 8 years old because people don't want to think about death, dying, and sickness. So it's not the most exciting subject matter, and therefore most people are not updating their documents every year or every other year. So the first thing is to take a look at what your lifetime protective documents say, and they all probably name the husband or wife who just passed, and they might name children in a certain batting order, and you say, gee, Charlie now lives in Los Angeles, and he's the one I have as my healthcare representative. So that the important thing is to update your documents and have them read in a present context, as far as upfront, instead of naming your spouse or providing outright or in trust for your spouse, have them streamlined. So if someone's reading what you've set up, it immediately covers your present situation, not your situation 5 or 6 or 7 years ago, or maybe in another state. So that I think is a front burner item that a lot of times it's hard because one is in the recovery process, and maybe that's one of the last things they want to start thinking about and doing. But to protect you, your assets, and your family, and not have things not go as easily as you would want them to for your benefit or for your family's benefit, it's important to try to bite the bullet and take care of those things sooner rather than later.
One of the things we have suggested for many years to our clients are very simple things. One, document the location of where you have important papers so your family members know. There's an awful lot of delay with getting things that the probate court may want, the attorney. So by documenting where a location, and you know, we use a location form that's very, very good, but you can make your own. I would suggest also the communication to your family members. You know, my grandfather, Anthony Mercugliano, would say, put it in the coffee pan, you know, buried underneath, you know. Never talked to my mom or dad about well, you know, that's the old, but I think nowadays you need to communicate. The laws are too complex. I've suggested yearly updates, yearly reviews. Michael mentioned updating documents. It's not a bad thing to assess yearly where your family dynamics are. There could have been a divorce, a new baby, a falling out, those type of things. So it's a yearly review. And then the last thing I suggest is that you sit down and write the letter to your loved ones and get some memories in those. Now, for an example, for all of my children, I have memory letters that they'll open when I'm gone, and we'll talk about the wiffle ball, the park, the slide, things that will bring their memories back. So those are just kind of nice things to do, and it's just an organizer, that type of thing.
I have one thing to add to that, Tom. You and I have both met with people and have emphasized to them the importance of not having any one or more of their assets listed in the newspaper in the tiny print as far as unclaimed property. And although spouses and even a widow or widower might know where all their papers are, what accounts they have, what items they have, no matter how close they are with their kids or family, those people don't know. And a big problem if something, God forbid, happens to a parent is the children many times are uneducated and they can't find everything. And if there happens to be an investment account with an investment company that the children aren't aware of, or a bank account like my grandfather had in New York City, even though he lived in Springfield, Mass, that nobody could ever find, those are missing assets that are very common in most people's estates. That it's unexcusable not to make sure that somewhere, maybe not with the children, but somewhere with a professional advisor, there is a current updated list of what all the items are, where they're located, what are their account numbers.
And passwords to your computers.
Exactly.
Huh?
That's becoming more.
That is a big
You know,
one.
I
That's a
tried to
big
tap
thing.
into the bank the other day. I couldn't find their password. It was terrible.
It's terrible.
Al, my buddy, always thinks big. So Al and I were having this conversation about
Right.
what the heck is happening on the estate tax level in Connecticut. Al, what do you think? Yeah, duh.
Well, let's talk about that. What does Connecticut estate tax, how does it work? What's it cover?
That's a good question because you have two things going on at the same time. There is a federal estate tax and there's a Connecticut estate tax. And the federal estate tax, over the years, the exemption has gotten very large. It's $5 million. So if somebody passes away and they have less than $5 million, there's no federal estate tax return to file. And about 3 years ago, the Connecticut and federal exemptions were identical at $2 million each. Then they both went up, IRS went up to $3.5 million, Connecticut went to $3.5 million. Recently, despite the fact that the Republicans and Democrats don't seem to get along as well as they used to, IRS exemption, Congress put together a jump from $3.5 million to $5 million about a year or so ago. Connecticut said, too bad, we're going to go down from an exemption of $3.5 million to $2 million. Now it sounds like despite that spread, which can be a very complicated thing estate planning wise, which I'm not going to get into, $2 million still doesn't sound too bad. But if you add up everything that is figured out as being part of the list of assets that the tax applies to, you find that life insurance proceeds, pension plans, profit sharing plans, money that we really don't think of as spendable right now, we're worth a heck of a lot more dead than alive, and many people don't realize that it isn't that hard to go above the $2 million threshold, and how to properly plan and have documents that try to preserve your assets and reduce the unnecessary estate tax exposure. So it's a real problem, especially in today's world.
And with good planning and not complicated planning, you can leverage $2 million to $4 million if you're married, and go beyond that because there are certain little things with life insurance. You can eliminate it from the taxation calculation by doing a few maneuvers, strategies. So by knowing a little bit more how to set up assets and retitling, and we do this all the time, we can really parlay a $2 million into $4 million or higher. So I mean, but that is critical because a lot of people, you're right, don't add up all these items, and before you know it, there's no planning. They leave it to their spouse, and now you can't do any other planning at that point. So
Right.
if you're married, you really need to put things together while you're married, because that's where the game begins, right?
I have a great question if someone wants to ask me it, and that is, what are the benefits or liabilities of jointly owned property?
I'm going to ask you that.
Oh,
Michael.
thank you, Tom. Joint ownership is hazardous to your wealth. And the reason why I say that is, take a simple $50,000 savings account that a husband and wife own in joint names and survivorship. And one of them innocently is in an automobile accident, 3 people are dead, and there's a $1 million umbrella coverage on the auto insurance policy, but we just happen to be $2 million short. So in today's world with a computer, they look up and they see what assets are in the couple's name to attach, and they find that joint bank account, husband and wife, $50,000. If they get a judgment, and if they're going after assets to collect, they don't get half the $50,000. The creditors or the people suing get all of it. Because either spouse can withdraw the $50,000, their creditors that are suing them sit in their shoes. So it's a much lower profile to have separately owned assets, have a joint account, checking account to pay bills and things like that for convenience, but have separately owned assets so that if someone has a catastrophic event and there's a suit, you only lose half of it, not all of it. The other thing is that that same position of having separately owned assets positions one for estate planning, using wills and trusts to have a much lower probate profile and estate tax exposure profile. The other thing is, lastly, if you have powers of attorney, you can have the beauty and convenience of joint so that each spouse can get into each other's assets. They just have powers of attorney filed, naming their spouse so that one person's the owner, but both people could be signatories on that asset. So that's a neat
That's
kind of
very
thing to
helpful.
do.
Is there a difference between durable power of attorney and power of attorney? I hear that bandied around, I'm not
Yeah.
sure.
I think that in today's world, every single power of attorney is a durable power of attorney.
Okay.
And the word durable only means that if I'm nuts and need a brain transplant tomorrow, that my power of attorney, though I lost my capacity, is not canceled. Under British common law, if you had a power of attorney, but after you signed it, at some point you lost your mental capacity and you became incapable, that canceled the power of attorney. So each state in the Union here in this country, and British law also says that if your power of attorney says that it survives any subsequent incompetence or loss of capacity, that's what makes it durable. They all say that now. That's a good question.
So you have a question?
Well, I hope it's not a diversion here, but in this context, you were talking about different kinds of assets being treated differently. What about an IRA? I understand that those get taxed differently in estates. And does it make a difference whether it's jointly owned? How does that work with the IRA?
Well, anything that you own in the estate, if you have ownership, will get taxed. The problem with IRAs, and people make this mistake, is all of a sudden they have a tax liability and their most liquid asset may be their IRA. So they pull out $200,000 to pay the state of Connecticut, which causes a $100,000 tax. And it becomes a looping, so it costs more money. So you have to be especially careful how you're using your IRAs. We just got the signal from the engineer that we have to close, as much as we're having so much time here. Michael, I want to thank you so much for your expertise in joining us today. Panel,
Thank you.
great.
Thank you.
Happy hour and
Nice
a
to
half
meet you.
hour.
Nice being with you.
But I would like to close by thanking you all for tuning in. Our panel was great, and we appreciate BCTV and Adi Norwood, our producer, and Alex, our cameraman, and tune in again. Thank you very much.
Bye-bye.